Hi, I'm Samuel. I will be presenting the introduction and the duty of care principle pre-Donahue and Stevenson, and the other members will be doing Donahue and Stevenson and post-Donahue and Stevenson. So, what is the duty of care? The majority of torts cover just a limited areas of protection. For example, trespass to land, defamation, false imprisonment. Outside all of this, the tort offers no protection. So negligence, on the other hand, is defined by the defendant's careless conduct. It improves liability in circumstances that the defendant owes the claimant called duty of care. Before we jump into the landmark case of Donahue and Stevenson, let us look at how the duty of care principle was before 1932. So before 1932, there was no case to establish duty of care. First example, we can look at the case of Winterbottom and Wright in 1842. The plaintiff, Winterbottom, who was a mail coach driver, was injured due to the breakdown of latent defects. Defendant Wright had a contract with the Postmaster General to keep the coach in a safe condition. The court later on held that defendant does not owe any duty of care to the plaintiff because the contract was between defendant and Postmaster General only. So by looking at this case, basically if there is no contract between the parties, the defendant does not owe any duty of care. However, later on in 1883, the case of Haven and Pender established that even there is no contract, under certain circumstances, one may owe a duty to the other. The facts are as followed. The defendant, Pender, who was the owner of the dock, supplied and installed the ropes around the ship. The plaintiff, which was a painter, was contracted to paint the ship. He used the ropes supplied by the defendant, and then the ropes broke. The plaintiff fell down and was injured. He had no contract with the defendant, so he decided to sue in tort. The Court of Appeal held that the defendant had an obligation to ensure all the staging and ropes for the plaintiff, who is a worker, they're safe and secure to be used. So accordingly, the defendant is liable for the plaintiff's injury. William Bragg's view, which was a minority in Court of Appeal, states that whenever one person is by circumstances placed in such a position with regard with another that everyone of ordinary sense who did think would at once recognize that if he did not use ordinary care and skill in his own conduct with regard to those circumstances, he would cause danger of injury to the person or property of the other. A duty arises to use ordinary skill and avoid such danger. Applying the above, we can say that the manufacturer, supplier, employer owe a duty of care to anyone they come into a contract with, even when there is no contract made between the two parties. So, these are some of the important cases pre-Donahue and Stevenson. So next up, my friend Yushen is going to talk about the landmark case, Donahue and Stevenson. So that is all. Thank you.
Hi, my name is Yushen, and now I'm going to talk about the Donahue and Stevenson, which bring a further extension of the development of tort of negligence. Let me brief the facts of the case. So, Mrs. Donahue, who is the plaintiff, poured some ginger beer to her ice cream and consumed it. While she was pouring the rest of the ginger beer, the remains of the snail fell on her ice cream. She then suffered stomach pain. However, she couldn't bring a claimant to the cafe owner as her friend had paid for the ginger beer. Therefore, she decided to sue the manufacturer of the ginger beer in the tort of negligence. The issue of this case is that whether the manufacturer is under any legal duty to take reasonable care of the consumer or the purchaser and guarantee that they are free from the effect likely to cause injury or loss of property. Lord Atkins's neighbor principle had said that you are to love your neighbor, you must not injure your neighbor. The definition of neighbor in this neighbor principle refers to the one who is so closely or directly affected by your act or omission that is being tort in the question. Basically, neighbor principle is used to examine the proximity between the parties and the foreseeability of the defendants. Lord and Kings had applied orbital dicta for the case Evan and Fender. The fact is that when a manufacturer produces goods to sell, he puts himself in the relationship between the end of consumer or the purchaser. Therefore, there is a liability imposed to the manufacturer for not taking reasonable care to the end of the consumer or the purchaser, which then lead to injury or loss of property. The reason Donahue and Stevenson is important because it brought a significant outcomes. Firstly, the negligence. The House of Lords ruling affirmed that negligence is a tort that said after Donahue and Stevenson, the claimant can bring civil actions against the respondent if the respondent's action had caused injury or loss of property to the claimant. Also, the lack of clarity of contract will not prevent the claimant from claiming. Next, the duty of care. This case has established the duty of care. This is stated according to Lord Atkin's ratio decision guide. Thirdly, the neighbor principle. This case provided Lord Atkin's controversial neighbor principle. For the conclusion of the case Donahue and Stevenson, we can find that legal decision making is abstracted from the previous cases. Lord Atkins examined the previous cases and came out that there are a variety of rules that need to be followed, and there must be a fixed element that will be followed, and claimed that it was neighbor principle. However, some criticize that neighbor principle is not developed, it's not found, but it was created by Lord Atkins. One example case that implied Lord Atkins' neighbor principle is the case between manufacturer and consumers. The case Grant and Australian Knitting Mills. In this case, Dr. Grant wore underpants which is manufactured by Australian Knitting Mills Limited for the whole week without washing it. In this case, we need to highlight that wearing underpants for a whole week without washing it is a common phenomenon in that era. He then suffered irritation on the first day of wearing the underpants, and he found that the irritation was actually dermatitis. So he blamed Australian Knitting Mills for not taking reasonable care when preparing and putting up the garments.
Thank you, Yushen, for presenting the development of tort negligence, the landmark case of Donahue and Stevenson. Hello, I'm Franklin, and after Yushen's presentation, I will continue with the Annes and Merton London case, followed by the two-stage test by Lord Wilberforce and how is Anne's test different from Donahue and Stevenson. Allow me to give you an overview of Annes and Merton London case. The fact was, the building had poor foundations since the local administration had not made sure that the construction corresponded with the designs, consequently endangered health and safety. Hence, the claimant successfully sued the builder and local council for negligence. Later, the House of Lords held that due to a breach of this obligation, the defendant was required to pay damages to the plaintiff, as the defendant had a duty of care to guarantee that the laws were followed when constructing the building's foundation. This then leads to Anne's test, Lord Wilberforce principle. The two-stage test, which consists of two stages. Stage 1. Did the claimant's harm meet the criteria for the neighbor principle? According to Lord Atkin's neighbor principle, foreseeability and proximity. If yes, a prima facie duty is said to be established. And stage 2. If the preceding question is answered in the yes, the court must determine whether there are any factors that could negate, lessen, or limit the duty scope or the class of people on whom it would be imposed. Now, how is the AND test different from Donoghue and Stevenson? Firstly, if damage is foreseeable, proximity is established automatically, rather than having to be established separately. And secondly, presumptions of duty exist, despite the potentially limiting nature of policy consideration. Although Lord Wilberforce's principle was adopted in the 1970s, however, there are many criticisms, such as the case of Yuan Kun Yew and AG of Hong Kong 1987 and Peer Body Donation Fund and Sir Lancey Parkinson 1984. The question of if AND's two-stage test should be implemented more strictly to ensure that the duty of care is not overly broad arose a short while after the principle was adopted, and was warned against treating AND's test being definitive by the courts in Peer Body Donation Fund. According to the concept established by Lord Atkins, the court also held that a relationship of closeness and neighborhood must be proven before a duty of care is considered to exist. But the extent of the duty depends on the specific facts of each case. The court must evaluate whether it is just and reasonable to impose a duty of care on a defendant before making its decision. It is the plaintiff, not the defendant, who must establish and support the existence of a duty of care when evaluating this fair and reasonable component in the imposition of a duty of care. According to Lord Kane in Yuan Kun Yew case, Lord Wilberforce AND's test had been given more weight than it should have, and in subsequent cases, it wouldn't be necessary to use this test to determine if a duty of care existed. Eventually, in the case of Peer Body Donation Fund, House of Lords denied a development business a remedy when they sued a local government for the financial damage brought on by a defective drainage system, whose plan they claimed the authority had authorized carelessly. And in Yuan Kun Yew case, Lord Kane held that he believed Lord Wilberforce had not intended for AND's test to be elevated to a degree of prominence greater than its merits. The criticism persisted, and in the end, Lord Kane brought up the question of the too literal application of the test in ANDs. In the case of Rowling and Takaro Properties, 1987, in Caparo Industry and Dickman, 1990, a new test put a stop to the divergence from AND's test. Next, I'll pass it to Xiong Yu, where he will explain about the Caparo test.
My name is Xiong Yu. I will talk about the Caparo Industry and Dickman case and the 3-4 test, as well as Murphy and Burnwood District Council case. Let's get started. The departure from AND's case to end with a new test in Caparo Industry and Dickman. The fact of this case is the defendant shareholders in a company invoke liability against the company auditors for having made inaccurate and misleading reports. Because of this case, the House of Law established a 3-stage test before a duty of care would be imposed. First, the court should consider if the damage is reasonably foreseeable. Although it was foreseeable that investors may use the audits from auditors to make investment decisions, the auditor who produced such audit would not be liable for losses as a result of audit being wrong to individual shareholders in making decisions for further investment in the company. Lord Johnson of Judicature used Kendall and Crane Christmas case as an example, state that only where the auditors was aware that the individual shareholders was likely to rely on the accounts for a particular purpose, such as his presence or future investment in or leading to the company, would a duty of care arise. Such a situation does not obtain in the present case. Hence, in this case, auditor cannot foresee the economic loss of the company and owe no duty of care to the shareholders. Besides, the court should consider whether there is sufficient proximity between the plaintiff and the defendant. In corporate cases, court decided that an audit of public companies under the Company Act 1985 was the making of a report to enable shareholders to exercise their class rights in general meeting. Audit was not intended to be a source of information or guidance for prospective new investors, and therefore could not be intended to help existing shareholders. The accountant knew nothing about corporate industry and did not know that corporate was going to rely on his report to make a decision. Therefore, the House of Law held that there was insufficient proximity between accountants and anyone and all who may rely on the accounts. Last but not least, the judge should make decision whether it is fair, just, and reasonable in all circumstances to impose a duty in the case, as law which mentioned in the case. The court considers it fair, just, and reasonable that the law should impose a duty of a different scope upon the one party for the benefits of the others. Fair, just, and reasonable mirror the policy consideration. House of Law decided that auditors ought no duty of care. Prior to Murphy, law breach described the current test of duty that is now recognized as conclusive in corporate industry and indictment case. The case itself deals with professional negligence and the issue of whether auditors could be held accountable when investors place undue reliance on their assertion. The case exemplified the extensive policy consideration that must be made to prevent opening the floodgates to negligence-related damage. Therefore, whether it would be just and reasonable to do so is taken into consideration to decide if an obligation should be placed on the defendant. On the other hand, the 3-4 test in corporate was applied by the House of Law in Murphy and Greenwood District Council case, is overruling the Ann's decision. The fact of the case is that the defendant local authority had negligently approved plans for the footing of a house. The claimant purchased the property and realized the problem afterward. The claimant was forced to sell his house at a considerable loss. He sought to recover his loss from the local authority. The House of Law declined to follow its previous ruling in Ann's and Merton London Borough Council case and held the defendant was not liable in negligence because it was a purely economic loss case. In a nutshell, the decision of a corporate industry and indictment case and Murphy and Greenwood District Council limited the scope of liability in negligence cases, especially Murphy, which stated that case of a pure economic loss were not actionable. Thank you. Now I pass the presentation to Jeffrey.
Thank you, Shunyu. Hi, I am Jeffrey, and I will talk about the 3-stage test. The 3-stage test was created as a result of Caparo and Dickman's 1990 rulings that the neighbor principle was too broad, and as a result, people were being sued for everything and were unable to sustain all the fresh legal claims. So next, I will be introducing the duty of care Caparo's 3-stage test, which is the foreseeability of damage, legal proximity of parties, and fair, just, and reasonable. Firstly, in terms of possibility, the claimant must be a member of a class that could reasonably be expected to suffer harm as a result of the defendant's carelessness, rather than the harm having to be forcibly occurred. Besides, possibility is an objective test. The court will inquire as to whether a reasonable person in the defendant's position would have reasonably foreseen that the claimant may be hurt or harmed. Like in Caparo's test, the accountant cannot foresee the economic loss of the company and owe no duty of care to the shareholders. In the case of Tort and London Country Bus, a minibus was left overnight in a lay-by by the defendant's transport company. The key was left in the ignition and it was unlocked. The bus was supposed to be picked up by the driver, but he did not arrive for work. The bus was stolen and the thief fled in it. A woman by accident was murdered when the bus ran over her bicycle. Eventually, her spouse filed a lawsuit seeking damages. the Court of Appeal held that the bus company owed no duty of care for the third-party actions. This case is significant to the law of negligence because it establishes the fundamental idea that there will be no duty of care if there is no possibility. Furthermore, proximity is the question of whether the claimant belongs to the group to which a duty of care was owed. In most cases, the court will infer proximity if there has been physical harm or property damages. In Hills and Schiff, Constable of West Yorkshire, a 20-year-old daughter of the plaintiff was attacked at night in the city street and later passed away. The defendant worked as the chief constable for the neighborhood where the street was located. The Ripper, who had already been convicted of killing the deceased daughter, is also accused of killing several other young ladies in the same neighborhood over a number of times. Because the police had looked into the earlier murders in the neighborhood, the plaintiff said that they had been negligent in failing to catch the Ripper and stop the killing of her daughter. The writ and statement of claim were dismissed by the Queen's Bench because they failed to state a cause of action. A duty to protect certain members of the public from particular crimes could not be imposed since there was insufficient proximity between the police and the public. Therefore, the family members of the Yorkshire Ripper's victims had no legal recourse against the police for any negligence or inefficient handling of the case. The judge should make a decision whether it is fair, just, and reasonable in all the circumstances to impose a duty in the case. Fair, just, and reasonable mirror the policy consideration. In the case of L and another, and reading for counsel and others, the interviews with the child render the local authority, social workers, and a police officer to believe that the father had mistreated the child. The judge later concluded that there had been no abuse throughout the contact proceedings, on the ground that the local authority owed him a vicarious duty of care. The father sought damages from the government and entity. His claim was then rejected, as it would not be just and reasonable to impose on a counsel direct duty of care to the father. In this case, the Court of Appeal denied his claim for damages. Where there is an established ground of liability such as personal injury or property damages, there is no need to apply the third stage of the Caparo test. This is only applicable where there is a potential new ground of liability. And right now, my team member Jim will final off with the Malaysian cases and conclude this presentation.
My name is Jim, and now I will proceed with the Malaysian cases. To determine the existence of duty of care in Malaysia, we adopted the neighbour principle put forth by Lord Atkin in Donahue v. Stevenson. The early case of Satu v. Hartonden, Rubber Estate Co. Ltd. in the 1961 is an instance of the application of the neighbourhood principle in Malaysia. In this case, the claimant's 19 heads of cattle strayed into the defendant's estate and ate the grass over there. A few days before, sodium arsenite had been sprayed into the property of the defendant's grass. Then, all 19 heads of the cattle had died a few days later as a result of feeding on the poisonous grasses. To the claimant's dismay, found out that all his cattle had died and brought it to the court claiming that they had committed a breach of duty of care. It was held that in order for the defendant to be liable in the neighbour principle, the claimant must prove that the defendant is aware that the claimant's cattle, but not any cattle, were likely to stray on the estate. Lastly, the evidence established that the defendant's company did not reasonably foresee the trespass on its estate to the plaintiff's cattle. The defendant's company therefore owed no duty of care to the plaintiff and consequently was not liable for the injury to the plaintiff's cattle. Another instance of the neighbour principle was found in the case of Lau Kwan Moy vs. Ramli bin Jamil and Government of Malaysia in 1984. During the Chinese New Year, a number of fishermen was caught gambling on a boat. Lau Kwan Moy, the plaintiff, being one of the gamblers, had jumped into the Muar River attempting to escape. He was drowned to death when the policeman refused to allow a passing fisherman boatman to save him, saying that he will be arrested if he interferes. As can be seen in this case, the police were not fully liable as the plaintiff jumped into the river knowing that he couldn't swim, which is a contributory negligence. However, the policeman who utterly trapped the fisherman to not save him could actually foresee that the plaintiff could drown to death. As a result, it was proof that the policeman has breached his duty of care and was liable for 75%. Over time, the test for duty of care has also developed, and Malaysian courts applied the Caparros test in determining the duty of care.
Start.
In the more recent case of Majlis Perbandaran Ampang Jaya and Steward Hua Jing Lun and others in 2006 was the case where the threefold test in Caparros industry was applied in Malaysia. This case was about the collapse of one of the Highland Towers, which consisted of 3 blocks of apartment known as the Block 1, 2 and 3. On December of the 1993, a landslide occurred resulting in the collapse of Block 1 and caused the evacuation of the respondents in Block 2 and 3. After the collapse of Block 1, MPAJ, also known as Majlis Perbandaran Ampang Jaya, promised the respondents that a master drainage plan for the affected area on the hill slope behind the Highland Towers will be implemented to ensure the safety and stability of the adjacent Block 2 and 3 occupied by the respondents. However, MPAJ failed to carry out the master plan. So, the respondents submitted that they deserve to recover the economic loss because, firstly, the concept of directing the river streams across the hill slopes to the Highland Towers are reasonably foreseeable. Secondly, there was a proximity as the drainage requires imposed by JPS, also known as the Department of Irrigation and Drainage, concerns the safety of the Highland Towers. And thirdly, whether it was fair, just and reasonable. This incident caused 48 deaths and many were made homeless. The High Courts held that the MPAJ is liable lastly. In this case, the test in determining the duty of care was no longer just foreseeability of damage alone, but requires the consideration of the proximity of the relationship between the parties and whether the circumstances is fair, just and reasonable. In conclusion, in Malaysia, the current test for existence of duty of care in Malaysia is the Caparros threefold test according to the federal courts. Thank you. So that's all for today. I would like to thank you for your attention and